All right. Welcome, everyone, and thank you for joining us today for Seyfarth's PAGA webinar Series 4 on motion practice, manageability, and trial plan. All participants on today's program are in listen-only mode. However, if you have any questions throughout the program, please use the Q&A section located on the right side of your WebEx window, and we will do our best to get to everyone's question. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and is required for CLE credit. CLE credit submission instructions, as well as the presentation recording and slide deck, will be distributed to attendees in the days following this presentation. I'm going to turn things over to Eric now to do some brief intros and a summary of today's agenda.
Thanks, David. Hi, everyone. Good afternoon. Thanks for joining us. My name is Eric Lloyd. I'm a partner in Seyfarth's San Francisco office. I specialize in labor and employment, specifically wage and hour matters. I'd like to take a moment to introduce our panel of speakers. First off, we have Ryan McCoy, an associate from Seyfarth's San Francisco office, who also specializes in wage and hour law. David Rosenberg from one of our Los Angeles offices, who's also a wage and hour attorney. And finally, Sherry Skibby from our Century City office, also a wage and hour attorney. If we turn to the next slide, I'll take a moment to give you a primer on what we're going to speak about today. Well, first up, the legal disclaimer. There is a legal disclaimer that appeared before the agenda slide, and that is just a reminder that we're not giving legal advice on this during this presentation. As for the agenda, a couple things. We're going to start out giving you some background on PAGA and the concept of manageability in federal and state courts. Then turn to a discussion of trial plans in the context of PAGA cases and why they're important. We'll then drill down a little deeper into the trial plan concept and talk about how the evidence fits in to a trial plan and what are some angles that can be used to attack the sufficiency of a trial plan in a PAGA case. Then finally, we'll talk about what happens next after a court has ruled on whether a PAGA trial plan is sufficient or insufficient. And with that, I'll turn it over to David for our first set of topics.
Perfect. So before diving into the concept of manageability, I thought it was worth revisiting some of the PAGA peculiarities that we covered in the first installment of this webinar series to kind of set the stage for today's presentation. The first peculiarity I wanted to revisit is the minimal standing requirements under PAGA. As mentioned in Series 1, standing under PAGA is very different than in traditional class action cases and really only has two basic requirements. The first of which being the plaintiff must be a current or former employee of the alleged violator of the labor code. The second being the employee must have suffered one or more of the labor code violations at issue. Once these very minimal standards are satisfied, a PAGA plaintiff can not only seek to represent other employees who allegedly suffered the same labor code violations as them, but the PAGA plaintiff can also sue for labor code violations that did not directly affect them. This relaxed standard for standing opens employers up to additional liability under PAGA than the employer would be under traditional standing requirements in the class action context that really require plaintiffs to have suffered the specific injuries they are suing for on behalf of themselves and the other class members that they seek to represent. Another major PAGA peculiarity is the lack of class certification requirements in the PAGA context. The California Supreme Court in Arias v. Superior Court held that a PAGA plaintiff need not satisfy class action requirements. Now in federal court, the Ninth Circuit has not expressly ruled on this issue, but it has declared that class actions and PAGA representative actions are more dissimilar than alike. In addition, a majority of district courts that have considered this issue have followed the holding in Arias and determined that Rule 23 class action requirements do not apply to PAGA cases. Now, I wanted to touch on these PAGA peculiarities because they inevitably lead to significant manageability concerns, given that plaintiffs in PAGA actions typically seek to represent the largest cross-section, if not all of an employer's employees, while at the same time, there's no gatekeeper function, as in traditional class actions, where employees must meet rigorous standing requirements and meet class certification requirements as well before proceeding on a class-wide basis. Now that we've set the stage for manageability issues, let's talk about them in a little bit more detail. So when I talk about manageability, what am I talking about? Well, manageability is the common sense concept that for claims to proceed to trial on a representative basis, they must be subject to some uniform policy or practice that apply to employees in some systematic fashion, or where the claims are subject to some other form of common proof. And now you're probably asking, well, why should manageability requirements apply to PAGA actions, and why should we care? Well, manageability requirements should apply because determining liability in a PAGA case must be accomplished without sacrificing an employer's due process rights. And a case is deemed manageable where determining liability on the claims at issue can be accomplished without sacrificing such things as procedural fairness or without abridging or modifying any substantive right. What this means as a practical matter is that in an effort to achieve manageability, trial courts may not relieve plaintiffs of their burden of proving the individualized elements of their claims and may not deprive an employer of the right to put on individualized evidence, to raise individualized defenses, or to receive a verdict on the individualized facts of each aggrieved employee's claims. Now, I bet you're wondering, well, where do these manageability concerns arise? Well, manageability concerns arise in the context of PAGA cases where there is a lack of common proof and where numerous individualized determinations would be necessary to determine whether any potentially aggrieved employee has in fact suffered a labor code violation based on the employer's alleged conduct. In these situations where a multitude of mini-trials are necessary, allowing representative actions to proceed on a group-wide basis is inappropriate. This concept of manageability has been recognized by the California Supreme Court in its decision in Williams versus Superior Court, which really supports an employer's arguments that trial manageability is a basic prerequisite for PAGA actions. Nevertheless, though, since the decision in Williams, the concept of manageability has been a hot topic of debate between plaintiffs and defense counsel in just about every PAGA case. And unfortunately for employers, it is far from a resolved area of the law. As you'll see on this slide, despite the Williams decision, state and federal trial courts have split on whether PAGA claims are in fact subject to manageability requirements. In cases where courts have found that manageability requirements do apply, the employers have typically painted a compelling picture as to how unruly a representative trial would be. For instance, employers have leveraged the factual record to show that a representative trial would require individualized testimony from a large number of employees, which would result in a trial that could realistically take anywhere from several weeks to months or even years to complete. Courts that impose the manageability requirement also do so based on due process concerns, which will be covered in more detail later in the program. So meanwhile, other courts, other courts have reached the opposite conclusion. These courts have ruled that PAGA actions are not subject to manageability requirements because such requirements are inconsistent with PAGA's purpose as a law enforcement mechanism. Or in other cases, courts have gone out of their way to assist PAGA plaintiffs with issues of manageability, including by utilizing various trial management devices such as bifurcation of issues, using the name PAGA representative as a test subject, or the use of statistical evidence or surveys, which don't always address an employer's due process concerns. This split in authority, much like in California state trial courts, the same split of authority exists in federal district courts, with cases going more or less both ways on the issue of manageability. Nevertheless, despite this split in authority, we believe that trial courts are increasingly striking PAGA claims where the experience of every potentially aggrieved employee would be required to show that they were in fact subject to any labor code violations. So even though manageability concerns may not always end up being present in your case, we believe that they should always be considered in the course of devising a winning strategy. So now I'm going to turn things over to Ryan, who will cover different ways of highlighting manageability concerns and ways to raise them with the court and opposing counsel.
Thank you, David. My name is Ryan McCoy. Thank you, everybody, for joining us here today. As David said, I really wanted to drill down into a couple of important questions. Number one, why is it so important to highlight these manageability concerns, and why should the court care? And number two is, when should manageability be addressed in the litigation? And we think, based on recent practice, that these issues should be raised early and often so that both the court and the plaintiff are aware of these issues and they know that they are issues that we intend to litigate throughout the case, so that things such as discovery do not get out of hand. And of course, this requires doing the work up front to investigate the claims, to assess the complaint in detail to see what it is that plaintiff is actually alleging. This requires, we think, developing the factual record early through discovery, communications with counsel in writing, all of which will help to challenge manageability down the road. Courts aren't necessarily inclined to address these things early on, but it is something that we should raise as early as initial discovery, in the initial pleading, and the initial CMC, so that they know that this is an issue that we intend to pursue. There really is no reason to surprise plaintiffs with these arguments and wait until later on. So at the beginning, when these cases start, we need to look at the LWVA notice and the complaint when they first come in, to analyze both the quantitative and the qualitative factors that are arising from these pleadings. And by quantitative factors, we're talking about factors such as the number of employees, job positions, departments, and the geographic regions or work locations at issue. If you're looking at the complaint and they are seeking to pursue civil penalties on behalf of each and every non-exempt employee in California spread across a number of different work locations, that immediately raises manageability concerns that we want to investigate, because who knows what policies and practices are enforced there. Qualitatively, we want to look at the variations in job duties by position, by department, by work location, and regions. And all of these variations will later help us to highlight individualized issues to build our case that this case is no longer manageable. For example, does the complaint allege an invalid meal break policy across California employees? Well, if we see that complaint, we should look at the policy and see what does that policy actually say. If the policy is actually lawful on its face, how can plaintiff use that as common evidence to prove their representative claims? They can't. And so that is a manageability concern that we want to raise early with plaintiff's counsel and the court. Next slide, please. And what are the key stages, the best opportunities to effectively raise these concerns early on? As I mentioned, the pleading stage. Identify and attack allegations showing any representative child would be unmanageable. California, the Code of Civil Procedure, and many local federal rules require us to meet and confer with counsel about the issues that we have with the initial pleading. And so I would recommend that you use this as an opportunity to call out these issues early on with counsel, to demand that they give an explanation as to why it is that they are alleging what they are, and identify what evidence is this actually based on. Assuming that they don't listen to your concerns, you can raise them at the initial CMC and call them out to the court so that they have an opportunity and that they are primed to understand what it is that we are going to raise down the road. And I would also use the opportunity of discovery to address the manageability concerns that arise from the complaint and the discovery that they are going to request from you should the pleading stay in the way that it is. Of course, the goal would be to attack the pleading, to get them to narrow the scope of the complaint, narrow the scope of the employees that they're seeking to represent through a PAGA claim, or to get them to add facts to actually support their theory, identify the common proof. Those are all ways to address the manageability concerns that arise from the complaint. In the beginning of discovery, challenging it early on gives you the basis to perhaps file a motion under the Code of Civil Procedure, Section 2019.020, a motion to sequence discovery so that you can investigate what it is that plaintiff is actually alleging, if plaintiff actually suffered any damages before they are allowed to conduct any unfettered discovery into the rest of the aggrieved employees that they seek civil penalties on behalf of. At bottom, though, this discovery should not be permitted, or the plaintiff should not be permitted to use their lawsuit to conduct what is essentially an audit of the employer's practices. And that's why it is so critical to raise these issues early and often with the other side. Next slide, please. And if motion practice with respect to discovery isn't advisable in your case, something else to consider is to prepare your written discovery responses that you do object and respond to, and assert those objections that are reasonable, of course, that the aggrieved employee definition is overbroad or burdensome, and demand that the plaintiff address their individual claims before their unfettered discovery is permitted. I would be proactive in these efforts and seek to meet and confer even before issuing your discovery responses, perhaps, so that we can work with plaintiff's counsel to reduce the scope of the discovery at issue. You can, of course, expect a fight from plaintiff's counsel, and because they believe that they're the private attorneys general who is entitled to walk in the door and conduct an audit. But if you are building your case early and often, the arguments are there to show that this case is not manageable. I would also finally take plaintiff's deposition early to help build the foundation for manageability. Try to understand what the scope of their allegations, what's their knowledge as to the actual complaint in this case. What do they know happened outside their position, outside their work office? Get key admissions from plaintiff that perhaps they don't know what's going on, or perhaps that they themselves did not suffer any injury and as a result don't have the requisite standing to pursue a PAGA claim on behalf of other employees. But throughout, continue to press them for a trial plan, especially if they refuse to narrow their complaint or narrow the scope of their aggrieved employee's definition. And to that issue, I would kick it to my wonderful colleague, Sherry Skibby.
Thank you, Ryan. Next slide, please. So we know that a PAGA action is a representative action, and it's usually alleged in a very bare-bones complaint on behalf of a large group of people. So how do you try this type of case when the number of potentially aggrieved employees is more than just a handful? This is where we suggest, and courts often now recognize, that the plaintiff must submit a trial plan showing how she can present evidence of a common policy that affects all aggrieved employees alike. And it's the plaintiff's burden to show that with a common policy. Next slide. So what is a trial plan? It's an actual document that describes what the claims and theories of liability are, and the witnesses, the number, the type of witnesses, and the evidence, the documents that will be used to prove these claims. And it's that presentation of evidence on behalf of the group of aggrieved employees that will alert the trial court to the amount of time that the trial is going to take, and the number of documents that's going to be introduced, and what kinds of experts will be needed, and the scope of experts. So that information is what you really want to press on, that the plaintiff has to paint the picture for the court. This is what it's going to look like. And when you have something that's as broad as most plaintiffs bring, which is every non-exempt employee in California or all salaried managers, you really are trying to explain to the judge what that judge is going to have to listen to, or what the jury is going to have to listen to if you can get a jury trial, and make what kind of decisions. Next slide. So if you're in a courtroom that does not regularly require a trial plan, or does not usually handle kind of complex litigation, you're going to have to answer probably at least two different kinds of questions. You're going to have to get the judge to order a trial plan, which plaintiffs invariably will oppose. First, you're going to have to explain what the trial plan is and why it's different than a typical scheduling or trial management order. This is not the kind of pretrial conference where you say an exchange witness list or exhibit list. This is not a single plaintiff kind of case. And then you're going to have to convince the judge to exercise his or her discretion to actually order one, and that it's in her interest to order one. So let's get the answers to these questions. The first one is about the manageability inquiry. And the reason why you want to have this kind of adjudication is that you don't want the individualized issues to overwhelm the common issues at trial. So you want to tell the judge, you need to look at this first before you actually go to trial, and then you end up with all these individual trials on issues of law and fact, particularly if you had an off-the-clock kind of claim or misclassification claim and what people are doing every day. So you want to have that inquiry well in advance of any sort of trial. And the answer to the second question of why it's going to be in the judge's interest is that it avoids wasting judicial resources for cases that linger on for many years, and they end up not being able to be tried. As one of the trial courts here in LA noticed, that manageability also considers the usefulness of the expenditure of judicial resources for the litigation of a representative action. So it's not just whether it's manageable, but whether you should be spending that much time and energy and court resources on the litigation of a representative action. The other issue is that it's due process, which we've been talking about, David and Ryan have been talking about, which is who's going to be bound by this decision? If you have just an amorphous group of people that you say are all non-exempt employees, who's actually going to be bound by the outcome of the litigation? And that should be decided well before trial happens. So as you know, PAGA cases don't have to meet class certification requirements, but the court does have the ability to control its own document, and that's paramount to this question. So you have on this slide some bases for how, or the grounds for why you should be able to have a trial plan, and put the burden on the plaintiff to show that he or she can actually try this case with representative proof. For example, in the Brown versus American Airlines case, next slide, the court struck the PAGA representative claims based on an overtime allegation. And it had already decided class certification and decided to deny class certification, and then went on to say there was too many individualized issues to determine an overtime claim for PAGA violations. Yet in contrast, it allowed the PAGA claim on behalf of the inaccurate wage statements to go forward because that was based on the allegation that there are two different pay periods on all of the wage statements. And because of that, that was easily manageable and they could have a trial on that issue. Next slide. So in Wesson, that's an alternative one, that's a misclassification case, and the judge decided that this was the time that 4 years of trial could not be devoted to spending to determine what the daily work was of each individual management level employee to determine if they were actually exempt or non-exempt. And so you want to highlight that that's going to waste so much of the court's time and resources, as well as be a result that you can't really enforce in order when you make your trial plan arguments. Next slide.
Right. At this point, I'll read the CLE code. The CLE code for today's program is SS, as in Seyfarth Shaw, 3889. Once again, that's SS, as in Seyfarth Shaw, 3889.
So what are the typical trial plans that plaintiffs usually present? Usually there's surveys or questionnaires they want to present, or some sort of testimony from a small number of cherry-picked employees that they found through a Bel Air West category or notice, or the employees knew. They also want to use expert witness testimony to replace actual employee testimony. Somebody will review depots and provide a summary, or they'll review the survey responses and testify as to what was said. And then maybe you'll have one or two company witnesses that testify about a policy or how payroll works. And these are fairly easy to attack because these plans are scientifically invalid and they deprive the defendant of due process. So they're not randomly selected employees, they're cherry-picked employees. And the sample size is too small and fails to meet the accepted statistical extrapolation practices that result in a margin of error of no greater than 5% with a confidence interval of 95%. Duran found this in a class action context, but this should also apply in a PAGA context. So if you have a few number of employees who testify about their own experiences, you can't extrapolate that across the entire group that they're trying to represent. The surveys and summaries don't permit defendants to cross-examine the witnesses. No one can identify or determine credibility or allow for the cross-examination in person. And then oftentimes, well, most of the time, plaintiffs ignore the defendant's side. So the defendants are allowed to litigate their own defenses, and they'll present their own trial plan. And that trial plan will be more scientifically valid and will be so large that this is your time to really attack the plaintiff's plan and explain, no, this is what you really need to do. If you have 350 potential aggrieved employees, you're probably going to have a sample size of 100 employees testifying in that case. And this is how long it's going to take, Your Honor, and this is what the experts are going to have to do. And that's why trial plans are very difficult for plaintiffs to actually meet. And in the one court case, Zheng versus Amgen, as the court recognized, the use of an expert to question employees about their job duties to determine how they spent their day would not lead to a valid statistical consensus of what the employees have in common, and the court struck the PAGA claims for the lack of manageability. But what happens when a court actually strikes those manageability, makes that manageability determination and strikes the PAGA claims? And I will turn that over to Eric for further analysis.
Thanks, Sherry. So let's talk for a moment about what happens after the court rules on the sufficiency of a trial plan. Obviously, if the court approves the plan, the case is going to proceed to trial, and trial in theory should proceed according to the plan the court approves. And that can be a good thing or a bad thing depending on the nature of the plan and what you're stuck with based on the judge's ruling. Where it gets a little more varied is where the court rejects the trial plan. A couple scenarios could happen. This is a non-exhaustive list. First off, the plaintiff could be permitted to pursue trial as to a more limited set of employees or claims than what is alleged in the complaint. Like you've heard throughout this presentation, one of the reasons a trial plan might be rejected is because the court has concerns that a trial might not be manageable. And these concerns often come up where a plaintiff tries to represent a really large group of employees that is not similarly situated. For instance, you could have a group of employees who are in different positions, different locations, who have different managers, who are subject to different policies. You could also have a particular claim that would be too difficult to try on common proof, such as the example mentioned earlier, where there is a facially valid meal period policy, which means that individual inquiries as to every employee and why they might have missed or had late meal breaks would be necessary in order to resolve that claim. The court could whittle down the aspects of the trial that it would consider to be unmanageable and let the remainder of the case proceed as to a group of employees that the court feels would be manageable to try the claims of, or as to a particular group of claims that the court feels would be manageable to try. Second thing that could happen, the plaintiff could receive an opportunity to submit a new trial plan. The rejection of a trial plan is not necessarily the death knell of a PAGA case, because the court can give the plaintiff another shot at coming up with one. And that's more likely to occur where the court thinks some of its concerns can be addressed if the plan is tweaked. And then finally, the last thing I'll cover with respect to what could happen if the court rejects the plans. One thing that was fairly common prior to a recent California Supreme Court case called Kim versus Raines International was that you would see, in some instances, the parties agree to settle the individual claims of a plaintiff who brought a PAGA case. The thinking there was that an individual settlement agreement would deprive the plaintiff of standing to pursue a PAGA claim because they've released everything that impacted them by signing a general release. The California Supreme Court in the Kim versus Raines International case threw a monkey wrench into that approach. There, the court ruled that an individual settlement with a plaintiff did not deprive the plaintiff of the ability to bring a PAGA case. One important caveat there, though, in the Kim case, the settlement agreement did not release the PAGA claims brought by the plaintiff. It only released the plaintiff's individual claims. So it's technically an open question as to whether the Kim case means that an individual settlement also releases PAGA claims can or cannot preclude a plaintiff from bringing a PAGA lawsuit. But what we do know for sure is that if the agreement does not release PAGA, then the plaintiff is free to pursue a PAGA claim. And we can go to the next slide, please. That's it for our substantive presentation. I wanted to let everyone know that this is number 4 in our series of PAGA webinars. Our first 3 are posted online. They are available. This one will also be posted online. Also wanted to give a shameless plug for our 5th chapter of PAGA webinars, which is coming up next week on December 15th. Next slide, please. Also wanted to encourage you, if you have any questions or if you wanted to discuss all things PAGA, our contact information is here. Please feel free to reach out to any of us. We'd be happy to talk to you. And then finally, next slide, please. Thank you very much for joining us, everyone. Have a great day.
Thank you.